Right. I think that hopefully everybody who's wanted to join has managed to. My name is Karolina Zielinska, and I'm a junior member of the Business and Property team here at 42 BR Barristers.
And I'm Howard Lederman, and I'm a member of the housing team and the business and property team.
And today we will be taking you back to basics with this webinar on forfeiture of both residential and commercial property. Now, if you have any questions throughout the session, we encourage you to use the Q&A box to ask those as we go along. We will try and address them as when it's appropriate, and potentially, if we have time, we'll do a Q&A at the end. I should also say, as a matter of housekeeping, an email containing the recording will be sent out with a feedback form at the end of this webinar. That will be circulated in the next few days, and the recording of this webinar will also be made available on our YouTube channel. So then, I suppose we should really begin with what exactly forfeiture is. I appreciate we're taking it right back to basics here, but it's always good to have a reminder.
Absolutely.
So to forfeit is to lose or be deprived of something. And in this legal context, it means it refers to a procedure that allows a landlord to bring to an end a contractual fixed term tenancy or lease before the expiry of the fixed period for which it was granted. So, for example, if I grant you a 5-year lease, if I exercise the right to forfeit, then I might be able to bring that to an end after 2 or 3 years, rather than having to wait out the full 5-year period. Now, in order to be able to exercise a right to forfeit, I've said there it applies to contractual fixed-term tenancies and leases. That's because there has to be a provision in that contract that says you can forfeit. Often that's worded as a right to forfeit. Sometimes that's worded in leases and tenancies as a right to re-enter the property. In essence, that means the same thing. So if you have a fixed-term tenancy or lease, that alone is not enough to exercise the right to forfeit. We also have to make sure that there is actually a clause in that lease that permits that. It's not a given otherwise. So once we have our fixed term tenancy or lease, and we know we have a right to forfeit, when do we forfeit? Now, usually this will be in circumstances where there is some default by the tenant. They've breached something, usually a clause in the lease or tenancy, they've done something wrong that will then allow you to exercise the consequential right to forfeit and bring the lease or tenancy to an end early. Now, it's important to remember at this stage that the way we deal with forfeiture in the residential context and the commercial context can be quite different. So if we're dealing with residential property, there are some additional considerations. In particular, there are additional requirements in law about how we go about evicting people from residential premises, because that's essentially what forfeiture has the effect of doing. In particular, if the property is residentially occupied, if it's let as a dwelling and somebody is lawfully residing within that property, then you must use court proceedings to remove that person from the property. You cannot simply change the locks on the property and go about forfeiture peacefully. You have to go through the whole court process. There's no remedy of self-help. Now, the situation is quite different if we're dealing with commercial property. That's right, isn't it, Howard?
Absolutely. So with commercial property, if the property is unoccupied, it is possible to re-enter by peaceful means, sometimes by changing the locks. But anyone who does that must be careful not to either use or threaten violence against anyone in the property who might oppose that re-entry. If they were to do so, that might amount to a criminal offence under the Criminal Law Act.
And that applies completely equally in the context of residential proceedings as well. In no circumstance do we want to be using or threatening violence in connection with evicting people from the property. So I suppose to sum that up then, no use or threatening of violence if you are going about the forfeiture process. But in the case of residential property, it will always need to be via court proceedings if that property is occupied lawfully by somebody. Whereas with commercial property, we can go in and change the locks peacefully. If you have the right to forfeit, there's not necessarily any need to go through the whole court process. Now, in terms of practical tips for taking back possession in that way, Howard, I'm sure you've come across similar cases. I tend to advise people to try and carry out that right of re-entry at a time when it's unlikely anybody will be there. Would you typically advise similar?
Right. So in terms of commercial property, what landlords often do when they want to forfeit, when they want to often change the locks, they often do that very early in the morning or late at night when it's believed that no one else is occupying. But before you do that, you need to double check that no one else is there, so there's no risk of committing an offence of threatening or using violence against anyone who might oppose entry. So that has to be looked at quite carefully before you do anything like that.
Now, we've talked a little bit there about the types of tenancy that might contain a right to forfeit, fixed term tenancies or leases. How might we approach, I suppose, forfeiture in the case of other types of tenancies, such as assured short-hold tenancies?
Right, so assured short-hold tenancies are dealt with quite differently, and it's not possible to exercise a right of forfeiture in relation to an assured short-hold tenancy. The only way in which you can secure possession is by getting an order for possession under Section 7 of the Housing Act 1988, or obtaining a demotion order, or in the case of a fixed term tenancy with a power for the landlord to determine the tenancy by exercise of that power. So forfeiture doesn't, for all practical intents and purposes, apply in the context of assured short-hold tenancies. So that's really important. In terms of residential tenancies, we're talking about long leases.
Yes, so one would have to, for those residential tenancies that are assured short holds, simply seek possession in the normal way, Section 7 or Section 21 proceedings. So if we have a think now about the types of default that might typically lead to forfeiture, I mentioned earlier that really what we need is not just the right to forfeit, but some form of default by the tenant. I think broadly we can categorize these into two types of default. Either non-payment of rent, service charges, or administrative charges, that's very, very common, or essentially other breaches of the fixed term tenancy or lease. So if we deal first, Howard, with non-payment of rent, service charges and administration charges, what sorts of things do landlords and tenants have to look out for in these sorts of circumstances?
Right, so in terms of residential tenancies where there's a dwelling, where there's non-payment of rent, there's a statutory requirement for a prescribed form containing certain information dealing with the amount of rent that's due, when it became due, and it has to be served within a certain period of time under the regulations that are set out in the Common Hold and Leasehold Reform Act. So that's for residential tenancies where there's rent. Where there's a commercial lease, of course, you need to look at the terms of the lease very carefully to make sure that the rent has actually fallen due and you comply with any contractual terms in the commercial leasehold agreement. Where there's service charge arrears, again, for residential tenancies, for dwellings, you need to make sure that the service charge, or indeed any administration charge, has been either admitted by the tenant or finally determined by the first tier tribunal or a court or arbitral body.
I think that's a really important requirement to focus on, because a lot of landlords might see that a service charge hasn't been paid and jump to forfeiture proceedings. But actually, if the tenant has corresponded perhaps with an agent or somebody involved with the service charge collection and said, actually, there's a reason I'm not paying this, I don't think it's been calculated correctly because of X, Y, Z, if that's overlooked, that will undo forfeiture proceedings if you try and bring them too hastily. Instead, it's really important to focus first on making sure that there has been a final determination. There's no way that the tenant can wriggle out of that payment first before you initiate forfeiture proceedings.
That's exactly right in the case of residential tenancies. In the case of commercial tenancies, again, there's usually a contractual regime that you need to look at very carefully to make sure that you've satisfied all the conditions of the commercial lease before you begin to forfeit. So the other thing to bear in mind with residential tenancies where you want to exercise a right of forfeiture for non-payment of rent or service charge or administration charge, the amount that you're seeking to forfeit for must be more than £350 or have been outstanding for more than 3 years. So that, again, that's another statutory requirement in the Common Hold and Leasehold Reform Act.
And I do think that surprises many tenants, doesn't it? Because £350 in the grand scheme of things is a fairly low sum upon which a landlord could theoretically forfeit an entire leasehold agreement, and that could be worth hundreds of thousands of pounds. So that can really catch out tenants, and I think often it's hotly debated in the media whether or not that ought to be raised. But for now, it is very much £300 or potentially a lower sum if outstanding for a longer period of time, at least 3 years.
That's exactly right. So the other thing we haven't yet mentioned is that where someone has some kind of mental health issue, it is possible for them to obtain a breathing space moratorium or some other insolvency issues. And if they were to go to a debt advisor and obtain a moratorium, it would not be possible for the landlord to proceed with forfeiture. And that applies to both residential leases and those relating to commercial property as well.
And presumably that's for the period of the moratorium.
Absolutely.
Rather than full stop. No, that makes complete sense. So I think then that predominantly deals with rent arrears, service charge arrears, administrative charge arrears. In terms of forfeiture for other types of breaches, in these circumstances, as long as it's not one of those three categories, the landlord is required in law to serve a Section 146 notice. Now, this is a notice under the Law of Property Act, which requires you to write to the tenant who's in default and specify the breach that you're complaining of, if it's capable of remedy, requiring that they remedy it within a reasonable period, and then also requiring the lessee to make compensation in money or otherwise for the breach. Now, this is really important because it's essentially the law giving the tenant a fair opportunity to be notified of what you say is wrong and giving them the opportunity to fix it. It might be that they're in breach of a lease and they simply don't realise. So, for example, if there was a covenant in my lease that said I had to maintain the garden at my property, we might have very different understandings as a landlord and tenant about what maintaining the garden means. So by sending that Section 146 notice, you're putting me on notice to the fact that you think I've not kept the garden in a good state, and I can then take steps to remedy that and avoid forfeiture proceedings if I simply didn't realise that it was a problem. So you might be thinking, well, okay, I can set out the breach that I'm complaining about and I can require them to remedy it. But what if I can't think of what a reasonable period of time might be to remedy it? It does seem a bit of a sort of finger in the air test. Now, unfortunately, it's going to be difficult in some circumstances to know exactly what a reasonable period might be. But the way we deal with that is that there is no requirement to set out in the Section 146 notice when you think that reasonable period ends. So if you're not sure, I was advised to err on the side of caution, serve the notice and wait a slightly longer period than you probably otherwise would. Absolutely. So you can be definitely sure that reasonable period has passed. Can be quite a while, but on the plus side, then at least you know for sure that you will have success and no issue as to period is raised once you get to the forfeiture proceedings in court. Now, I've also said that in that Section 146 notice, we need to set out if the breach is capable of remedy, a requirement that the tenant remedy it. Now, not all breaches are capable of remedy. Am I right in thinking that, Howard?
Yeah, absolutely. So some breaches we can identify that can be put right quite easily. So, for example, if you were to breach a covenant relating to a requirement for insurance, that's capable of remedy relatively quickly. There are other breaches where there's been an assignment that hasn't been authorised. That's not going to be capable of remedy usually.
And generally, I think this is something that's explored quite well in case law. There are certain types of breaches that come up very frequently, such as unauthorised alterations. And so in doing research in this area, you can quite easily identify whether something is generally taken to be remediable or not. With alterations to property, typically it tends to be a question of fact and degree as to whether you can undo that alteration. It might be easy, say, to knock down a shed. It might be a lot less easy to remove various partition walls you've installed in a property without permission. It will depend on the circumstances. Another interesting category, I think, of what can be a remediable or irremediable breach is when a property is used for illegal or immoral purposes. Historically, a lot of the case law on this involved properties being turned into brothels. Now, in those cases, again, historically, illegal or immoral use would typically be seen to be irremediable because it attracts stigma that's attached to the property because it's been used in that way. So the damage reputation is being usually seen as something that can't be cured. However, there have been quite a few cases involving subtenants where, say, I have leased the property to a leaseholder, they have in turn sublet, and it's their sublessee who is using the property for an illegal or immoral purpose. Now, in those cases, generally the courts tend to hold that if you kick out the subtenant, if you end that sublease, then that can't form the basis for forfeiture between the freeholder and the leaseholder. Now, that does seem to be a bit of an odd conclusion, simply because if the damage to reputation is remediable in those circumstances, one could argue, why isn't it also remediable where it's the leaseholder who's using the property for illegal or immoral purposes? But that's, I suppose, a question to be argued in future cases. Unfortunately, there's not much definitive authority on that as of now. So, we serve the section 104. Oh, apologies, Howard.
So, no, there's just one other thing that we didn't mention in relation to a section 146 notice. So where there's a repairing covenant and where there's more than 3 years of the lease yet to run, you've got to put a notice in the section 146 notice, enabling the tenant to apply for relief under the Leasehold Property Repairs Act 1938. And that will put a well-advised tenant on notice to serve a counter notice, and then the landlord will have to apply to the court for permission to forfeit in those circumstances. So in all these kind of cases where there's any doubt or difficulty, what we usually advise is to get some expert evidence about the state of the property, what's involved, the amounts involved, and whether or not it can all be remedied. And if so, at what cost? And you do that really well before you serve the section 146 notice, ideally.
That's good advice. And I think as well, if we're thinking about red flags to watch out for in this area, we talked in the context of service charge arrears in residential properties, that those need a final determination before one can proceed with forfeiture proceedings. Are there any similar rules in the context of breaches that don't relate to rent, service charges, or administration charges?
No, not really. No, not in commercial properties. You don't need a final determination, but you would certainly want to make sure that any conditions precedent, any other contractual conditions in the commercial lease were satisfied before you served your section 146 notice. And then, of course, there are other provisions of actually serving the notice. You'd want to make sure that the notice got to the tenant, and you'd want to carefully look at the lease to see if the provisions of section 196 of the Law of Property Act 1925 were incorporated, which permit service at the premises or at the last known address of the leaseholder.
Always worth thinking about service, but luckily for us, it is very clearly set out in section 196 what exactly and how exactly you need to serve the notice, what you need to do, whom that needs to be served on, where it can be served. All of those requirements are set out there, which does make things a lot easier for landlords. With that, I will perhaps come on to talking about waiver of the right to forfeit. So in what circumstances, Howard, do you find that the landlord can lose the right to forfeit, can waive it?
Right, so this is a well-known trap, a well-known difficult area for landlords. So the right to forfeit is treated as a right for the landlord to choose between keeping the lease as it is on foot or to terminate. And the landlord has to choose between those two courses of action. So if the landlord were to take a step that acknowledges the existence of the lease, that will be treated as waiving the right to forfeit. And if that has to be done with knowledge of the breach, if the landlord has knowledge of the breach. So the classic example of that, the classic example of an unequivocal act which recognises the lease as being in force, is where the landlord demands and or accepts rent after knowing about the breach, for the period after the breach. So that's a classic example of where the landlord could lose the right to forfeit.
Yes.
Having started the process of.
So the key there is, I suppose, that the recognition is that the lease is continuing after the date of the breach. I suppose in theory, it would be fine to recognise that the lease was in existence before the breach. No one's arguing about that. But it's just if you accept that it continued after that point, then that could waive the right to forfeit. Most likely has waived it.
That's exactly right. And so this often gives rise to controversy, and particularly when landlords or their agents more often send rent demands or demands for service charges or other payments such as administration charges for the period after the landlord or the agent knows about the breach. So often there's an argument about whether or not the payment of rent or service charge relates to the period before or after the breach. So what often happens in those circumstances is that the landlord is advised, the landlord and the agents are advised not to serve any communications that might be interpreted as recognising the lease, and not to serve any demands for rent or service charge at that stage.
Absolutely. So I think often the way this is done is by putting what's known as a rent stop on an account. So often property managers, agents of the landlords themselves will simply put out a message to say, do not demand any more rent from this person. We are thinking of forfeiture proceedings. I mean, crucially, it's the demands for rent as well as the acceptance of rent that could waive the right to forfeit. So it is really important to make sure that everybody who could potentially inadvertently or advertently waive that right is aware of what's going on and knows not to either contact the tenant in relation to the future rent or accept it. Howard, I think one other thing I find is good to advise in this context when trying to ensure landlords avoid an accidental waiver of forfeiture is also to make sure that, that where we have payments being received from a tenant, that those are dealt with very promptly. First, I typically advise landlords to contact tenants to let them know that they won't be receiving future rent, just to make the position very clear. And sometimes even to say that if monies are accepted, unless it's otherwise stated by the tenant that they will be accepted as going to arrears only, accruing prior to the date of any breach of covenant. That is, however, perhaps a slightly more risky strategy than just not accepting anything. That's always the gold standard following a breach that you want to rely on in forfeiture proceedings. But equally, not every landlord is in a position to just not accept any money for the foreseeable future whilst waiting to forfeit a lease. So a middle ground can be just to make sure that it's only rent accepted in that period before the lease is treated as having come to an end by reason of forfeiture. So if we come back then for a second to thinking about waiver of forfeiture, we discussed that in order to waive the right to forfeit, you need to have knowledge of the breach that has been committed. Now, it's important here to note that you need knowledge of at least the basic facts that amount to a breach of covenant. If you're not aware of even that basic minimum, then you won't be taken to have sufficient knowledge to waive at that point, even if you do accept rent for an ongoing period or similar. The burden of proof in showing that the landlord has knowledge of a particular breach of covenant is actually on the tenant, which does help landlords in these circumstances. It is for the tenant to prove on the balance of probabilities. And I think the most important other point to make in this area is that when it comes to waiver, whether or not that means you will lose the right to forfeit forever depends entirely on the type of breach that we're dealing with. So predominantly we have two main types of breach. We can have continuing breaches and we can have once and for all breaches. They pretty much do what they say on the tin. So if you have a once and for all breach, if you waive the right to forfeit for that breach, that's it. You can't undo that. There's no future right to forfeit that would arise as a result of that particular breach. You have to wait for the tenant to come along and breach it in some different way or again before you can pursue forfeiture. However, if we're dealing with a continuing breach, that means that every day the breach continues, you effectively have a fresh opportunity to rely on that breach for the purposes of forfeiture. So really, really important to establish before you issue proceedings whether or not a breach is continuing or once and for all. Now, very similar to whether something's remediable or irremediable, this is something that's been borne out in the case law. Again, there are lots of legal sources online where you can find long lists of what's typically considered to be a continuing breach and what's typically considered to be a once and for all breach. But by way of example, continuing breaches are typically breaches of things like covenants to keep something in repair, covenants to insure, and once and for all breaches are typically things like breach of a covenant to pay rent. So if you waive the right to forfeit for rent in a particular period, that's it. Unfortunately, you can't come back from that. Same with breach of a covenant against subletting or to carry out repairs where it's by a specific date rather than just generally. Now, we also discussed waiver in a bit of detail there. We talked about the types of things you can do to inadvertently or advertently waive the right to forfeit. But I think one interesting thing to explore is what we do if a tenant is there offering rent in hand, because that's quite often what happens once we send the relevant notices and you take the relevant steps to prepare for forfeiture proceedings. So if I have a tenant who approaches me and says, here's some money for the rent, how would I approach that, Howard?
Right. So I think if you were looking to forfeit, you would have to make sure that any monies that were accepted from the tenant related to the period before the breach that you're complaining about. You'd have to agree with the tenant that the sums would be appropriated to any arrears before the breach that you're complaining of. So that's a key thing. Because if you started to accept monies that were due after the date of the breach of covenant, then you're at danger of waiving the right to forfeit for that. You would almost certainly want to make sure that an agreement was reached that whether or not you were guaranteeing full relief from forfeiture and whether or not the tenant was going to pay your legal and administrative costs of forfeiting and any Section 146 notice or any other costs involved. So you really need to document that, any acceptance, very carefully. The issue arises, I think, as you were hinting, Karolina, at where the tenant might want to try and allocate the rent to a different period.
So if I'm a tenant and I write in and I say, okay, here's £500 for my service charge this year. I know, let's say that's after my previous failure to pay for service charges. How would you approach that as a landlord, where I've specifically said I want it to go towards this year?
So I think you'd have to reject that, and you'd say, well, if you want us to accept those monies, it will have to be allocated to an earlier period so that we preserve the right to, the landlord preserves the right to forfeit. And that if necessary, you'd have to actually send the monies back. And you need to do that really very quickly as well.
Yes.
You can't wait for 2 or 3 months.
So, for example, if I've paid by direct debit and I just haven't cancelled that direct debit, so the next month's service charge gets paid, then if that's not sent back from a landlord's bank account very quickly, then that may well waive the right to forfeit, even if it wasn't a consciously accepted payment. Similarly, sometimes tenants might send checks. Again, in those circumstances, best not to cash it. If you can, return the check if it's specified to relate to a period that's after the breach that has led to potential right to forfeit. One must be very, very careful about accepting any sort of further monies that might demonstrate that lease or tenancy is continuing. And as we discussed earlier, the best way to avoid that is usually to write to the tenant at an early stage, say, I'm only going to accept any monies towards arrears from before the date of breach. And then if the tenant doesn't say anything when they send in money, you are, I think, well within your rights to allocate that towards the arrears as intended. If the tenant specifies that they want it allocated in a different way, then be very, very cautious about accepting those sums. And if you do, make sure that you return them quickly. If it becomes apparent that actually those sums went to periods after the lease was allegedly forfeit. So now we know what to watch out for in terms of waiver. I think it's a good point to come on to actual forfeiture proceedings. So of course, we're seeking effectively the right to re-entry into the property and regaining possession of it as a result of the forfeiture of the lease or fixed term tenancy. Most landlords are not going to be very happy about not being able to accept rent, service charges, etc. in that period in which they are refusing the rent because they don't want to make it look like the lease or tenancy is continuing. But equally, they need that income whilst they're waiting for the lease to be forfeit. Howard, what would you typically recommend that landlords do in those situations?
So what landlords normally do is that when they have satisfied themselves that they're in a position to pursue forfeiture and all the preconditions have been satisfied, within any proceedings, with any claim form, you put in a claim for what are called mean profits. And that's just another name for damages for trespass. And that is a claim for all the monies that have fallen due after the period in which, after the forfeiture, that's after the date of service of the claim form. And that can be done without waiving the right to forfeit. And then also within the claim form itself, you would also be drafting a claim for any monies that fell due up to the date of breach. And what usually happens in those situations is that the court will either offer the leaseholder relief from forfeiture upon terms that all the monies outstanding are paid, or the leaseholder itself will ask for what's called relief from forfeiture, which is an offer to reinstate the lease or to continue the lease upon terms that any arrears are paid and any costs are paid, usually on the indemnity basis. So essentially, what's going on here is a cash flow issue. The landlord usually will and should get back all the monies that it may have refused in the meantime. The other advantage for a claim for mean profits is that that can be claimed at the market rent or the rack rent rate. So if the long lease, the ground rent or other rent in the lease has been set many years ago and rents have gone up since then, the landlord actually can claim quite a large and higher amount. So that's something to think about.
I mean, absolutely advantageous for landlords in that situation. In terms of how you would practically go about proving that in court proceedings, would that typically be, I presume, by a mix of documentary evidence going to rents in the same area and perhaps even surveyor's evidence?
That's exactly right. Normally, you'd get a valuer or a local estate agent who's familiar with rental values. But ideally, you'd get an expert valuer to say, well, this is the market rent, this is the value at which the lease could have been let out for, the premises could have been let out for during the period after forfeiture. So potentially, that could be quite a valuable right for many landlords if forfeiture succeeds.
And I suppose that brings us on quite nicely to talking about the importance of thinking about whether or not forfeiture is actually right for your client in all the circumstances. Because of course, the market rent at the time may well go up, but equally, I'm sure we can envision scenarios where you forfeit a lease, and actually the rent, the market rent you might well get if you move in a new tenant is going to be very poor if the market's dipped since you obtained that first lease or tenancy. And indeed, that may well mean that you're left with a longer void period than expected. And if that's not something that your client is in a position to deal with, then actually forfeiture might not be quite right for you, particularly if there is a chance that the tenant might ultimately pay up eventually. So worth thinking about that, both at the outset, but also keeping under consideration as you take the various steps necessary to begin forfeiture proceedings, because everybody's circumstances can change at any moment, and that might well make a big difference in whether or not you continue to pursue that remedy. So I think perhaps now is a good time to come on to questions that you may have about forfeiture. We're more than happy to assist. I think we've got one in the chat so far. I can see that somebody has asked, I'm afraid I can't see the names of people who've asked questions in the chat, but thank you very much. Is the waiver argument valid for breach of a repairing covenant? So as we discussed earlier, breach of a repairing covenant, by and large, will be a continuing breach, which means that if it has been waived, then as soon as potentially even the next day, you can rely on that continued breach for fresh forfeiture, I suppose is the best way of putting it. So yes, waiver is relevant. If you've waived, that might affect forfeiture proceedings that you've tried to bring, but equally that right to forfeit will renew on a daily basis in most circumstances.
So can I just add to that? I mean, I think we need to be clear. We're talking about a repairing covenant that is a covenant to keep in repair. So I think what Karolina says is absolutely right. The other thing to think about is that where you have a specific item of disrepair, let's say the roof is in disrepair, it might be possible to waive that breach of that repairing covenant in relation to the roof by, say, demanding and refusing rent, demanding and accepting rent. But if there's another covenant relating to a front door, you might not be able to. That might relate. You might be able to waive that separately. So I think you do need to look at these repairing covenants separately and the particular factual circumstances relating to that.
Brilliant. All right. Well, if anybody has any further questions regarding forfeiture, now is your opportunity. Otherwise, I think it's time to say thank you all very much for attending. And the recording from this webinar will be available shortly. It'll be sent out by email, but it will also be available on our website and YouTube channel in due course. Please do let us know if you have any feedback. Sophie will be sending around a feedback form as part of that post-session email. Let us know if you'd like a follow-up webinar on any of the topics we raised today. I think waiver forfeiture definitely is its own can of worms. Yes, lovely to have you all join us. Thank you very much.
Thank you very much. Good to speak to you.